This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Today, I wanted to share a story about a judge shutting down a ridiculous argument that a police officer should be immune for framing a son for a serious crime, resulting in his 23-year imprisonment because the teen's mother refused to sleep with the officer. You heard that right, and it only gets worse from there. This is the story of Lamont McIntyre, the 17-year-old son of Rose Lee McIntyre, who served 23 years in prison for a crime he did not commit, as retaliation for his mother refusing Officer Golubski's advances. Now, the court's decision is 70 pages long, so I'll only be reading parts of it and focusing on defendant Golubski, but we'll post the full opinion at lawfulmasses.com. But first, we need to know what qualified immunity is and what it's for. Qualified immunity is the legal doctrine in U.S. law that shields government officials from being sued for discretionary actions performed within their official capacity unless their actions violated clearly established law or constitutional rights. Qualified immunity thus protects officials who make reasonable but mistaken judgments about open legal questions, but does not protect the plainly incompetent or those who knowingly violate the law. This is supposed to let police officers and public servants make good faith decisions when acting within the scope of their duties without being held personally liable. The clearly established part of the rule means they don't have to be psychic or predict what a future court will think was the correct course of action. Rather, they have to follow past rulings as to what constitutes a violation of rights. Since qualified immunity is an exemption from lawsuits, it's a defense that's raised immediately in a motion to dismiss before even answering the plaintiff's complaint. To decide whether qualified immunity applies, the judge assumes the well-pled facts in the complaint are true. In this case, Golubski has tried to argue that his actions to frame a teenager in retaliation for the mother rejecting him is covered under qualified immunity. Let's see what Judge Catherine Vratiel thinks of that. On September 20th, 2019, Lamont McIntyre and Rose Lee McIntyre sued the unified government of Wyandotte County, Kansas City, Roger Golubski, and several other officers. Plaintiffs allege that defendants arrested, prosecuted, and imprisoned Lamont McIntyre for a crime that he did not commit, and they bring various claims under 42 U.S.C. 1983 and state law. That's one of the civil rights statutes. Since the early 1980s, Roger Golubski used his power as a police officer to force vulnerable black women in the north end of Kansas City to sleep with him. To do so, he threatened arrest and prosecution, fixed tickets, made warrants disappear, and paid money. He would often fixate on particular women, hounding them continually for months and even years. These predilections were well known among other officers and supervisors within the Kansas City, Kansas Police Department. They knew, and even joked about, Golubski's practice of arresting black sex workers, forcing himself on them, often at the precinct house itself, and then releasing them without pressing charges. Golubski also used these women as informants to help him clear cases. Known by other KCKPD officers as Golubski's girls, the women would provide critical evidence which resulted in convictions in many of Golubski's investigations, evidence which the officers knew was unreliable because it was the product of coercive relationships. Golubski also worked closely with kingpins in Kansas City. Golubski was paid to fix investigations, including framing innocent people for gang-related crimes. Despite this being common knowledge, the KCKPD never reprimanded him. In fact, before he retired, the KCKPD promoted Golubski to captain. Although many kept quiet out of fear of retaliation, since his retirement, several current and former KCKPD officers have blown the whistle on Golubski's conduct. At least 2 have given sworn statements which describe his treatment of women and the permissive supervision that allowed it to continue. Rose McIntyre was one of Golubski's victims. In the late 1980s, Rose was sitting in a car when Golubski pulled up and demanded that she accompany him to his unmarked squad car. There, he threatened to cause trouble for Rose if she did not allow him to do what he wanted. Rose, a mother of 5 children who had never been arrested, surrendered to the threat and went to the police station the next night, where the officers took her directly to Golubski's office. There, he repeated his demands. During the ensuing assault, another officer opened Golubski's door, saw what was happening, and left without saying anything. For weeks after, Golubski harassed Rose, calling her 2 or 3 times a day and telling her that he wanted a long-term relationship that he would pay for. Rose repeatedly rejected his advances, but Golubski's harassment did not stop. As a result, Rose had to move to a new home and change her phone number. At the time, she believed that this marked the end of Golubski's attention. Neil Edgar Jr., better known as Monster, worked for a Kansas City kingpin. On April 15, 1994, Monster took Danielle Quinn's and Donald Ewing's lives as they sat in a parked car. Monster received $500 for the planned hit against Quinn, who was suspected of stealing from a stash house. Although Monster's role in the crime was widely known in the community, 2 leaders of the gang have since sworn under oath that Monster did it, Monster was never prosecuted. He's currently serving 33 years for unrelated offenses. Lamont McIntyre is Rose's son and was 17 years old when Quinn and Ewing died. He didn't know anything about them and wasn't involved in the crime. When it happened, Lamont was with his family. Defendants did not conduct investigations of the Quinn and Ewing hit to bring the guilty parties to justice. Whether to retaliate against Rose for spurning Golubski's advances, to protect Monster's bosses from prosecution, or to quickly close a double homicide, defendants framed Lamont for crimes he did not commit. To do so, defendants fabricated evidence, withheld exculpatory evidence, and deliberately chose not to take basic investigative steps which would have exonerated Lamont. Golubski had relationships with 2 of the eyewitnesses to the crime, Ruby Mitchell and Stacy Quinn. Mitchell observed the incident from her front door, but could not identify the perpetrator. She did, however, provide Officer James Michael Kristalich a description which did not resemble Lamont. Later, Golubski drove Mitchell to the police station for further questioning. During the car ride, Golubski made suggestive comments and implied he would charge her with solicitation if she did not cooperate with his investigation. Shortly after this interaction, Golubski and Kristalich forced Mitchell to falsely identify Lamont in a photo array. The array only had 5 photos. 3 were Lamont and 2 were of his close relatives. Photo arrays are when the police show pictures of potential suspects rather than have a traditional lineup. But what's described here isn't how photo arrays are supposed to work. There should only be 1 photo of the suspect, and the other photos should be of somewhat similar looking people. Eyewitnesses are notoriously unreliable and can be influenced by things like how many times a face is shown to them. This array is not recommended procedure. But why was Lamont even in a photo array? He had no connection to what happened. According to Golubski and Kristalich, Mitchell said that she recognized the assailant as a man named Lamont, so they gathered photos of people named Lamont and she identified the plaintiff by his first and last name. Of course, it was impossible for Mitchell to do this because she did not know him or his name. It also doesn't explain why none of the other photos were people named Lamont, or why she was shown Lamont in 3 different pictures. Later, Golubski and Detective Dennis Ware visited eyewitness Nico Quinn and attempted to use coercion and suggestion to elicit a second false identification. To do so, they used the same suggestive array that they had shown to Mitchell. When Nico could not identify the shooter, Ware pointed to Lamont and revealed his name, indicating that she should choose him. Nico refused, however, to make the false identification. A week later, Golubski met with Nico Quinn and pressured her to make the false identification, eventually promising to help find her a new home if she cooperated. There are multiple levels of misconduct being alleged here. Pressuring witnesses, rigged photo arrays, and lying to the prosecution and the court are obviously big problems. But by saying that the prosecution never disclosed this information to the defense, the plaintiffs are also trying to call this Brady evidence. The Supreme Court ruled in Brady v. Maryland that evidence a defendant could be innocent, also known as exculpatory evidence, has to be disclosed to the defense. Here, the plaintiffs are trying to say that Lamont's rights were violated when the police lied to the prosecution and didn't disclose their misconduct. Nico finally saw Lamont for the first time in person at a pretrial hearing. At that time, she realized that he could not have been the shooter because he was much taller and had different facial features. She immediately tried to correct her false identification, telling prosecutor Tara Moorhead that her identification was inaccurate. Based on Golubski's assurance that Nico Quinn had previously identified Lamont freely, Moorhead did not believe that the retraction was credible. At some point before trial, Golubski and other unknown officers contacted Nico through a relative and threatened to take her children away and put her in jail. Knowing Golubski was serious, Nico testified against Lamont at trial. In 1996, and again in 2014, Nico gave sworn recantations of her testimony, declared that Lamont was not responsible, and described the coercive and suggestive identification procedures that Golubski and Ware conducted. From beginning to end, the investigation lasted no more than 6 hours. The only evidence that the officers collected against Lamont were fabricated identifications by Ruby Mitchell and Nico Quinn. Hours after the first eyewitness, Ruby Mitchell, adopted the initial false identification, but before police had developed any other evidence inculpating Lamont, Barber and Golubski tracked him down and arrested him. After the arrest, Barber and Golubski prepared police reports which falsely claimed that Rose had made statements implicating her son. Specifically, they falsely reported that Rose, Lamont's mother, had asked whether a person who killed someone could be arrested, and that this inculpated Lamont because no one had yet told Rose what crime they were investigating. Moreover, they falsely reported that she had given Lamont a bogus alibi. On September 29, 1994, a jury convicted Lamont, relying entirely on evidence that defendants had fabricated. The 2 false eyewitness identifications from Ruby Mitchell and Nico Quinn, and false inculpatory statements that defendants attributed to Lamont and Rose. On January 6, 1995, Lamont was sentenced to 2 consecutive life sentences. In 1996, just over a year after Lamont's sentencing, Nico and Stacy Quinn both came forward with affidavits attesting to Lamont's innocence and stating that he looked nothing like the true perpetrator. Nico fully recanted her false trial testimony, and Stacy also testified unequivocally at the hearing that the assailant was not Lamont McIntyre. Over the next 2 decades, Lamont and Rose fought, but failed, to prove Lamont's innocence through direct appeals, habeas petitions, and post-conviction motions. Ultimately, the kingpin, who employed Monster and an associate, both swore in affidavits that Monster had taken Quinn's and Ewing's lives in retaliation for Quinn's suspected theft. Based on this and other new evidence, Lamont moved again to vacate his conviction. On the second day of a scheduled 6-day hearing, the Wyandotte County District Attorney concluded that Lamont's conviction was manifest injustice and moved to dismiss the indictment, stating that new evidence regarding the identification of Mr. McIntyre could have certainly added reasonable doubt to Lamont's trial. On October 13, 2017, the District Court of Wyandotte County, Kansas, vacated Lamont's conviction and the prosecution dismissed the charges. Beginning at the age of 17, Lamont had spent 23 years in prison for crimes he did not commit. The plaintiffs have 9 counts or claims in their complaint, but I'm going to focus on the ones against Golubski. The plaintiffs allege a lot of wrongdoing, but in summary, they allege violations of their First, Fourth, and 14th Amendment rights through Lamont's false imprisonment, evidence fabrication, Brady violations, and malicious prosecution. Your Fourth Amendment right involves protection against unreasonable searches and seizures, while your 14th Amendment right protects against state due process violations. But what about their First Amendment rights? Well, you also have a right to a freedom of association, which includes with your own family. By targeting Lamont and framing him, Lamont and Rose were robbed of their right for Rose to raise her child and for them to live and spend time together as a family. Although Golubski attacked each count from various angles, I'm going to focus on the statute of limitations and qualified immunity defenses. Statutes of limitation create a time window that you can sue in, but once too much time has passed, you lose your ability to sue. The beginning of this time window is referred to as when the claims start to accrue. Golubski argued that the statute of limitations for false imprisonment has long since expired because the claims started to accrue when he was first put in prison in 1994. Anyone else see a problem with that? The justice system hasn't even acknowledged its mistake yet, and it's a long and difficult process to overturn a jury verdict. In this case, it took 23 years for a court to finally say Lamont shouldn't have been convicted, despite key witnesses in the trial recanting their testimony. Let's see what the judge has to say about Golubski's argument. For Section 1983 claims, or civil rights claims, arising in Kansas, the court applies a 2-year statute of limitations. To determine when the claim begins to accrue, the court applies federal law. While a false imprisonment claim begins to accrue when the false imprisonment ends, a malicious prosecution claim does not accrue until the criminal proceedings terminate in plaintiff's favor. Under federal law, this malicious prosecution claim did not begin to accrue until October 13, 2017, when the District Court of Wyandotte County, Kansas, vacated Lamont's conviction and the district attorney dismissed the charges. Lamont filed his initial complaint on October 11, 2018, well within the 2-year statute of limitations period. So yes, common sense wins out. The clock for the statute of limitations started once the justice system acknowledged Lamont had been falsely convicted. This is also known as the Heck Doctrine. If your claim can only proceed once you prove you were wrongfully convicted, then the clock starts once the court acknowledges the miscarriage of justice. The court also spent time explaining the difference between false imprisonment and malicious prosecution. False imprisonment is when you are detained without due process, for example, a warrantless arrest without probable cause. Malicious prosecution is when you've had access to some due process, like a trial, but that process was tainted and resulted in a false conviction. Here, Lamont actually has claims for both, because he was arrested before there was probable cause and then was later convicted based on fabricated evidence. Next, Golubski tried to say that Lamont can't bring his claims for malicious prosecution, evidence fabrication, and Brady violations because the criminal proceedings didn't end favorably for him. This is because only people who are innocent can sue for those types of claims. Golubski tried to argue that when the prosecutor withdrew the charges against Lamont, he was only using a standard of reasonable doubt of whether a person was guilty, which is not the same thing as being innocent. The court called this argument frivolous because there was new evidence that Lamont was innocent. 2 kingpins gave sworn affidavits that a hitman was responsible for the crimes. It's not like the charges were withdrawn out of mercy or in exchange for cooperation. Next, we have the qualified immunity defenses. Under Count 3, Lamont and Rose assert familial interference claims against Golubski, alleging that after Rose rejected his advances, Golubski retaliated against her by orchestrating the wrongful conviction of her son, Lamont. Golubski asserts that the court should dismiss the familial interference claims because he is entitled to qualified immunity and those claims are time-barred. To overcome a government official's qualified immunity, plaintiffs must demonstrate that 1. The official violated a statutory or constitutional right, and 2. The law clearly establishes that right. Here, Golubski challenges plaintiffs' claims under the second prong, arguing that the right to familial association, in the context of the particular allegations in this case, was not clearly established in 1994 when his alleged conduct occurred. Specifically, although the right to familial association was clearly established in 1985, he argues that it was not clearly established in the context of wrongful prosecutions. In other words, Golubski argues that he is entitled to qualified immunity because by 1994, the 10th Circuit had not clearly established that his alleged actions, falsifying evidence to wrongly convict a son because a mother rejected the officer's advances, violated their constitutional rights. A constitutional right is clearly established when it is sufficiently clear that every reasonable official would have understood that what he is doing violates that right. Although the Supreme Court has warned against defining a clearly established right at a high level of generality, and that the law must be particularized to the facts of the case, this does not mean that a right is only clearly established if a case exists that is factually identical. In other words, the clearly established prong does not require plaintiffs to show the very act in question previously was held unlawful. This makes good sense. If a right is only clearly established if a case exists with identical facts, qualified immunity would apply whenever a different fact pattern arises. Under this standard, officials would always be entitled to qualified immunity so long as their actions, no matter how outrageous or harmful, are sufficiently novel. The 10th Circuit has accounted for this potential of rewarding particularly egregious conduct, explaining that the more obviously egregious the conduct, in light of prevailing constitutional principles, the less specificity is required from case law to clearly establish the violation. See Duran v. Surgidas. It would create perverse incentives indeed if a qualified immunity defense could succeed against those types of claims that have not previously arisen because the behavior alleged is so egregious that no like case is on the books. In 1994, the right to familial association was sufficiently clear that every reasonable official would have understood that what Golubski was doing violates that right. By 1985, the 10th Circuit had made clear that intentionally and unlawfully interfering with familial relations is unconstitutional. According to plaintiff's allegations, Golubski assaulted and harassed Rose, and she repeatedly rejected his advances, changed her phone number, and moved to a new home to hide from Golubski. To punish Rose for her rejections, Golubski took away her son by framing him, coercing identifications, fabricating police reports, and suppressing exculpatory evidence. Golubski's plot succeeded. Lamont was wrongfully convicted and spent 23 years in prison. As a result, Rose suffered extreme emotional and psychological devastation. Golubski is correct that in 1994, no 10th Circuit court had held that an officer violates the clearly established right to familial association by framing a son for serious crimes in retaliation for a mother's rejection of advances. But every reasonable officer would have understood that this egregious conduct violates that right. The court overrules Golubski's motion on this issue. Golubski asserts that the statute of limitations, then, bars Lamont's familial association claims. The court applies a 2-year statute of limitations because the injury under a Section 1983 claim is a violation of a constitutional right, and it begins to accrue when plaintiff knows or should know that his constitutional rights have been violated. When the Section 1983 claim necessarily challenges the validity of a conviction or sentence, the Heck doctrine delays the accrual date until the conviction or sentence has been invalidated. Here, plaintiffs allege that Golubski deliberately interfered with their familial relationship by committing constitutional violations which caused Lamont to be prosecuted and convicted for crimes that he did not commit. Accordingly, to succeed on their familial association claims, plaintiffs will have to show that Golubski intentionally and unlawfully interfered with their relationship by causing Lamont's wrongful prosecution and imprisonment. This necessarily implies the invalidity of Lamont's conviction. Accordingly, Heck delays the accrual date for plaintiff's claims until Lamont's conviction was invalidated, which was October 13, 2017, well within the 2-year statute of limitations. Wow. So to recap, the court dismissed Golubski's argument that Lamont should have sued for malicious prosecution and wrongful imprisonment during the first 2 years he was in jail, and has now rejected that Lamont was imprisoned too long for plaintiffs to bring their right to familial association claims. Any argument that Golubski somehow had qualified immunity for his actions has also been firmly dismissed. Remember, qualified immunity is supposed to protect public servants who make good faith decisions in their official capacities where the law isn't clearly established. There was nothing good faith about this. Just because the case is so egregious that there wasn't case law regarding it prior to 1994 doesn't mean that the officer gets protection from personal liability. Any reasonable person should have known this was wrong. However, getting past statute of limitations and qualified immunity defenses is just the first hurdle in a lawsuit against police. Golubski and the other defendants will now need to answer the complaint with their version of events, and then the case moves on from there. It may still be years before we get to the end of the case, but we'll keep an eye out for updates. As I film this, I know there's a good chance that YouTube will demonetize this story, even though we're bringing it to you for legal educational purposes. It would be impossible for us to bring these types of stories to you without your support. If you'd like to see more videos like this, please check out the link to our merch store in the description below. We've just come out with a new design featuring Ilsa and Nico, my dogs. More designs are coming soon, so check back regularly. Lawful Masses is a community-supported legal education channel that we're trying to take to the next level. Your monthly support on patreon.com/ljfrench and sponsors.com/law keeps this channel going and supports our creators and staff. Thank you to the following supporters who pledged $50 or more in the month of March: Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, and Anders Thorenfeldt. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me. All $5 plus supporters also appear in the description of the videos we produce. Thank you for watching. I hope you and yours are safe and well in these trying times. Stick together, separately, and we will all get through this soon. I'm Leonard French, your favorite copyright attorney. I love you all. See you in the next one. Bye.